I'm pleased to announce that Getman Sweeney has filed a federal lawsuit against Central Refrigerated Service Inc. and Central Leasing Inc. on behalf of owner-operators. The case is brought by 4 different law firms to address primarily Central's treatment of owner-operators, calling them independent contractors when by law Central exerts so much control over how the drivers drive that they have to be deemed to be employees as a matter of law. The effect of that is that Central violates the Fair Labor Standards Act by not paying drivers as employees and by making deductions for the driver's expenses, such as the lease payments, gas, tolls, equipment such as the Qualcomm, insurance, bonding requirements, etc., etc., etc. As an owner-operator, you know all of those expenses that you have to bear and that get credited against the pay you get from Central. The claim is that the Federal Fair Labor Standards Act requires at least the federal minimum wage for all hours that a driver works for the company, and that deductions that bring those wages below that amount are unlawful. To be part of that aspect of the case, you must file what's called a consent to sue form, and that consent to sue form is available on the Getman Sweeney website, getmansweeney.com. Additionally, there's another claim in the case, which is that Central engages in unlawful forced labor by requiring drivers to drive only for Central and threatening that if a driver turns in the truck, they will be forced to pay Central back the full value of the lease payments, and that the Central will make negative entries on the driver's DAC report. If you have any questions about the case, please call us. If you've driven for Central in the last 3 years and you want to be part of the Fair Labor Standards aspect of the case, you must file the consent to sue, but please contact us at getmansweeney.com. Thank you.